Good morning, good afternoon, good evening. As part of the Mediation Symposium 2022, we bring you the sixth in the series of Commercial Stability in a World of Conflict, co-hosted by JAMS and the Chartered Institute of Arbitrators. Please note that this webinar is being recorded and will be available after the event. In episode 1 of this series, in April, I mentioned two different worlds that I've inhabited alternately during my career. That of mediation practice in international intervention and development, dominated by interdisciplinarity and known as conflict resolution, and mediation practice in the civil commercial environment, intimately connected with the legal profession and dominated by legal discourse, and known as alternative dispute resolution. Many on each side of this divide are unfamiliar with the other side's literature and discourse. And this sixth episode, Mediation, Fragile Settlement, or Transformational Development, draws on an accusation sometimes levelled at ADR by conflict resolution, and that is that ADR is obsessed with settlement and ignores deeper issues, questions, and opportunities to address underlying interests and needs. For those who've mediated in the commercial context, the clarity that the parties' wishes are paramount mean the answer is simply the parties want swift settlement, and the major part of this is usually facilitating a distributive negotiation process. However, most also vehemently maintain that we're not simply messengers. We work with the legal, the personal, and the commercial, and we challenge, we reality test in a more or less facilitative way, depending on our style. So do we as mediators recognize, and do we have the skills to navigate exploration and reality testing when long-term issues such as whether agreements are going to fall foul in relation to sustainability and principles or practices of sustainable development are on the table? And if there's always a trade-off between cost, speed, and quality in terms of outcomes, what do different areas of mediation practice have to learn from each other in how to help parties navigate the balance between getting settlement and achieving sustainable outcomes when the two things don't always coincide? My name is Isabel Phillips. I'm Director of ADR and Mediation Development at the Chartered Institute of Arbitrators, and I'm co-moderator of this webinar together with Nikki Borowski of JAMS, who I'll introduce shortly. The format of this session will be 1 hour and 15 minutes long. We might nick a few more minutes at the end, but let's see how we go. After this short introduction, there'll be thoughts from our three speakers, then discussion and Q&A. So please do add questions and of course, any technical issues, the chat is there and there'll be people to help you. So now on to introductions. First, Mohammed Raja is a former associate professor at the University of South Africa's Graduate School of Business Leadership and a CEDA accredited mediator. From 1980 to 2016, he lectured in labor law, conflict management, industrial relations, and dispute resolution. So he's worked for more than 30 years in mediation and arbitration within that arena. And he's now a part-time academic and a full-time ADR practitioner. So by my maths, that makes definitely more than 100% working time, which is why he's currently on a webinar at 11 o'clock at night at his time. So thank you for being with us, Mohammed.
It's a pleasure. Thank you.
Next, we have Jimena Bustamante, who is founding partner of Pactum Dispute Resolution Consulting, a full-time mediator with experience in over 1,000 cases, including highly complex disputes and controversies with the public sector, both in Ecuador and abroad. She was ranked as one of the top 3 mediators in Ecuador by the Leaders League in 2021 and 2022, and is also on the UN mediation roster. Finally, Hiro Aragaki is a Chartered Institute, an active dual-qualified international arbitrator and mediator at JAMS. And when I say dual-qualified, I'm referring to the US and the UK specifically. He is also a tenured professor of law and director of the Center for Negotiation and Dispute Resolution at the University of California, Hastings College of the Law in San Francisco, as well as a professorial research associate at SOAS School of Law in London. Finally, Nikki Borowski, I've mentioned already, my co-moderator, Senior Global Practice Manager at JAMS Local Solutions, She is an attorney, mediator, and promoter of creative, thoughtful dispute resolution processes. Prior to her role as Senior Global Practice Manager at JAMS, she was a Vice President at the CPR Institute. She's worked in-house at Alstom as well as in the international arbitration practices at Latham and Watkins and Proskauer in Paris, France. So welcome to all of you, and over to you, Nikki.
Thank you so much, Isabel, and thank you again for this opportunity to collaborate with Ciarb. This is the 6th installment in a vision that my former colleague Rance Howell put into motion months ago now, and we're ready to delve into questions of how mediation can help and whether it is a fragile settlement or a transformational development opportunity. I just want to give a little bit of background and context to how this series came about. And it really was JAMS seeing the way the world was changing, the conflicts arising, and anticipating the client's needs for innovative dispute resolution and options that we wanted to put on the table for disputes that we saw. So this is all part of a campaign of listening, tailoring, adapting, and training to the purposes and problems that are on the horizon. The framework that we're working with, a very brief overview, is really the purpose of this 6-part series, and we keep on adding parts just because the conversation has been so robust, is really to bring together a diverse variety of voices to engage in a timely conversation about the overlap of conflict resolution and dispute resolution. As Isabel was saying, there are worlds which sometimes are doing the same sorts of things, but very infrequently collide and collaborate and share. The disputes and the conflict that we're experiencing, I don't need to belabor. We all have seen on the daily news and in our emails and amongst our friends and colleagues and at work, the kinds of challenges that are facing the world right now. War, climate change, global warming, supply web disruption, conflicts that are arising in contracts, and increased business risk, all combining with social, economic, environmental, and governance challenges. I wanted to just highlight for all of you that are joining us just today the full, robust extent of the 5 previous sessions that we've had. They've all been recorded by Ciarb and are available on YouTube free of charge to watch and to engage with and listen to. And I highly recommend engaging with this conversation if you have time. The overall picture has been 5 webinars, 11 guest speakers with their own perspectives, and thousands of virtual audience members who've been engaging and questioning and asking dangerous and interesting and challenging prompts for everybody to speak to. The purpose of today's session is really to offer you some practical tips for sustainable mediation. What do we mean by sustainability? Our speakers will speak to that. They may have different answers. They'll be challenging each other. They'll be challenging you. And we hope that you will challenge all of us as we navigate the challenges and see how mediation might lend itself to sustainability and addressing some of these issues. We're also building on the dialogue that happened on Tuesday, the first day of the Chartered Institute's Mediation Symposium. How can the flexibility of mediation help to address these challenges? I would like to replace alternative, maybe with adequate for ADR, for dispute resolution that can really adapt to urgent crises, the kinds that we're seeing more and more. And I think that we'll also touch upon points that Georgina and Andrew, 2 of the speakers for Tuesday's sessions, highlighted about the need to speak broadly and reach new audiences, and also addressing how mediation really does address a solution where not just one party can win, and that will support and underscore sustainability matters. So in closing, before we get to the real reason why you're here, I just want to say that it's a great opportunity to listen, acknowledge, learn, respond, and engage with you in this conversation. And that really is another prompt for you to pop your questions into the chat and follow up as best you can. Thank you so much. And now I'm handing it back to Isabel for the real discussion to begin.
Thank you, Nikki. So we're going to start off with some impulses from each of our speakers in turn, and then we'll get into discussions. So I'd like to hand the mic, first of all, to Mohammed, if you would pick it up and run with it. Though if you give it back at the end, then we'll be able to hear the others too. So.
Thank you, Isabel, and thank you for inviting me to be part of this panel. When I saw the title firstly, and when I was asked to come on, sort of, the fragile settlement or transformational development, and I thought of that, and the first thing that came to mind is ongoing relationship, but also the triple constraints theory that you mentioned, and then I thought, are the two mutually exclusive? Can you not have both? And obviously that's what mediators, we need to realize, that you can have a settlement and it doesn't have to be a fragile settlement. It could be a good settlement and have the transformational development. And there's examples in political, in labor disputes, in family disputes, family business disputes. And South Africa obviously is one of the places where we've shown this in transformation. And there are other studies as well. And I know that project managers grapple with, obviously, the triple constraints theory. And in that case, perhaps you can't have all three. Perhaps you can have two, or have all three, but to a lesser or greater extent. But as mediators, we know that at times, depending on the issues and the nature of the dispute, that settlement is almost the most important part of the mediation for some parties. They wanted to get it over with, the relationship is not important. In that case, obviously, that's fine. However, in family, employment, business, partnership, and more so political conflicts and disputes, transformation and the ongoing relationship are important. So I'd like to point a broad picture of mediation in South Africa to aid this discussion. We have the Center for Constructive Resolution of Disputes, a CORD, a civil society organization. They work all over Africa to bring about creative African solutions to the challenges arising from conflicts. They've identified mediation considerations such as prioritizing issues, inclusivity, stakeholder dynamics, leadership and ownership, and these are important elements and inputs for the mediation. And it's important for securing negotiated agreements and in shaping longer-term societal consideration. The South African experience has demonstrated that mediation efforts are important, conflict transformation is possible. Clearly, it's not an instant occurrence, and as mediators, we know that. It's a start. It starts a process for the parties. It starts transformation. It maps out or the route. It paves the way for the parties to continue. In my own mediation practice, in dealing mainly with labor disputes, I do some commercial, some social, some community, but in my own mediation practice, which is mainly labor, I'm guided by the South African labor law, which prescribes, and it mentions conciliation, which we, of course, is mediation for us, as the compulsory first stage of dispute resolution. The South African Labor Relations Act of 1995 has as its main purpose to advance economic development, social justice, labor peace, and the democratization of the workplace, in other words, transformation. So that for me, in a nutshell, it was. And in our political arena as well, we've had transformation as a result of mediation. I know you said at the beginning we have a little, so I'll stop there. Further, we can deal with in question time or discussion time. And obviously, there's quite a lot more I can say.
I'm sure there is. Thank you, Mohammed. A really interesting starting point. I'm going to hand straight over on that note to Jimena.
Thank you so much, Isabel, and thank you so much to the Chartered Institute of Arbitration and to JAMS for hosting this and for thinking about this and for making us think about this, because I you know, as a mediator, you're not usually seeing the big picture, but just inside a case, in the specific case where you are trying to find an opportunity for parties to find settlement, to reach a final decision, to go home in peace, and you're not actually imagining what are the impacts for this kind of work that we do, and what is really our responsibility, and how can we actually help reach this goal of sustainability and sustainable development. So one of the questions that I was asked, and something that I really want to take a hold of, also listening to prior series of this webinar, it's this mediation with the government or with a government agency for which Ecuador has a lot of experience. And thankfully, Ecuador has a lot of experience, which allows me to talk to you about this today. But we do mediation regularly with either national or foreign investors, helping people reach solutions and resolutions that have impact in the whole country and have impact for the future of that relationship and for the future of the people that are the beneficiaries of whatever work was there. So we have issues as investor state, and as you know, the investor state system in itself seeks to provide investor with appropriate protections at the time it ensures the flow of foreign direct investment into countries as Ecuador. So mediation comes in a way as an important aid into that objective. But we also have mediations in public procurement cases, or even reparation of human rights with people that have been, it has been already sentenced that their human rights have been violated, or they are in the course of the international human rights courts, and we try to provide them with an adequate space to deal with their issues and have the government be liable, but also accept the responsibility that they've had, if they had any. And then now, and this is very new, we are starting with tax mediation, which was something that was not heard of before. So all these kind of cases that are not normal in civil law countries, I do think are important to promote the sustainable development. On one, I already mentioned, they keep the relationship of the parties, as Mohammed said, more often than not, is that parties reach an agreement because the private entity wants to continue doing business with the country, and they need to find a way to settle whatever it is that is being a rock in the road that doesn't let them continue. So they find a way to settle and continue on with the relationship. The other thing that they do is we ensure or try to ensure the termination of the infrastructure project when this is the question at hand. And that allows for the community to actually have that infrastructure project, although I think that maybe mediation comes a little bit late, and we should start thinking about dispute boards as a better way to ensure this termination of infrastructure projects. The other thing that we do with mediation is that we ensure the work with formal investors that comply with regulations and environmental and tax regulations and other regulations, because if we don't do this, we don't have a good relationship with the government and the investor, private investor, either national or foreign, you get all of these informal people that are taking advantage of whatever they have, like in mining, for instance, not complying with environmental regulations. So this is also a way to ensure sustainability. And finally, we are helping through mediation to develop conflict resolution skills within public entities, which has allowed them to settle the future disputes. So I have a case that if I have a second, I can tell you, we had this long mediation with a telecommunication company about interconnection, an issue that had been going on for 10 years. And it had already, a part of it was in arbitration, another part of it was in an administrative procedure, and another part of it was in a judicial procedure. So we started the negotiation, and part of the mediation meant having and developing teams within the public entity. Finally, we reached a settlement. But after the settlement, this entity came back to mediation, then they settled 3 more cases very fast because they were already prepared and they could do this. And it was easier for them, and they knew the ways and how to reach those agreements. So the next conflict is also, I think, part of thinking about sustainability and how to reach this goal of peace that we are actually working for. Thank you so much, Isabel. Back to you.
Thank you, Jimena. Really, really interesting. And I'm itching to ask questions, but I'm going to be very restrained and move on as it should be to Hiro, who I'm also eager to hand the mic to.
Thank you, Isabel. Thank you to Ciarb and JAMS for inviting me to participate, and thank you all for joining us today. I'm going to throw out a couple of questions maybe and thoughts, responding a little bit to what I've heard so far. So I'm really taken by this distinction that's been drawn between fragile settlement and transformative development. I'd like to kind of mind that a little bit more. We talked a little bit about relationship and that being more on the kind of transformational side than the fragile side. And, one thing I just want to underscore is the fact that, just because parties don't agree to preserve their longstanding relationship, it doesn't necessarily mean that the settlement was fragile. So if you think about a dispute, say, between 2 businesses that have been doing business for a long time and have had a lengthy relationship, and they go to mediation, and the mediation is just all about money and severing that relationship and not preserving it, is a money-only settlement more fragile somehow than a settlement that would result in, entering into a new joint venture, perhaps? And I think that's a real question that, we need to think about, right? Because sometimes real transformation happens because parties do sever their relationship, because they buy each other out, and because they move on. And by contrast, sometimes staying in that relationship is a form of fragile settlement, because sometimes parties are afraid of change, or because they're not willing to invest the effort that it really takes to find something that works better. So the mere fact that a relationship is preserved is not necessarily, to me, an indication that there's been something more transformative versus something that is fragile. We all know about unworkable relationships that really are worse than the alternative of just cutting things off. The other question that I would like to raise really is, we seem to be speaking about fragile settlements as if they're a bad thing. But I think in reality, the question is not whether they're bad in the abstract, but really bad compared to what? So compared to something like transformational development, fragile settlement doesn't sound all that appealing. But what about compared to no settlement, right? So in my experience, it's often hard enough reaching a fragile settlement at all. Isabel was talking about reality testing and pushing the parties and so on. And I find in my mediations that I am pulling out every trick I have, just to get them to finally meet at a number. And so to me, I guess I would suggest that maybe the real choice is often between fragile settlement and no settlement, right? And I think that most of us would prefer a fragile settlement to a much less sustainable option, namely litigation. And let's not forget that litigation really is the unsustainable choice here, right? It's impractical, it's wasteful, it's unnecessary for every dispute to go all the way to a full hearing on the merits. And this applies both to litigation and arbitration. By contrast, mediation can be accomplished in a fraction of the time, at a fraction of the cost. It's more accessible to the ordinary disputant, and so improves access to justice and also allows us to scale up dispute resolution. It can result in global settlements and not just the settlement of narrow legal claims. It can also result in creative and more satisfying solutions that no court could ever possibly award. So every one of us that contributes somehow to this endeavor of mediation, either by advising our clients to try mediation, teaching the next generation of students about conflict resolution, or even just by acting as a mediator, all of us are already doing our part in promoting sustainability within the dispute resolution ecosystem. And I think this is a really important point just not to lose sight of, right? Mediation really is the sustainable dispute resolution option, which is why the world can no longer really afford to ignore mediation anymore.
Thank you. A very, very persuasive case there, but made very eloquently, I think. Something that I think it would be a nice point to pick up with. I think it does highlight one of the things that certainly in my experience of the commercial world, that getting a settlement and being able to let go of litigation puts people on a very different footing, because exactly that because of what the other options are, which is going forward into a litigative process. I think you put that case so eloquently. I'd quite like to go back to Jimena and Mohammed in terms of the two different contexts that you're in, and just get some thoughts around that point.
Thank you, Isabel. If I can, I absolutely agree with Hiro in what he is mentioning. Really, when you have parties in a mediation, you are in between no settlement and litigation and fragile settlement, which really we're talking about money settlement, and money comes from one side to the other, and that's already very hard. Then I think the next question is, what if you see an opportunity to promote a new business relationship if there is a chance? I don't think that every case is good for that. I think that we should be realistic and adapt to whatever it is that the parties need and try to help them reach whatever it is that they need. But if there is a chance, if we spot that piece of light, are we responsible for following that opportunity? Should we promote it? Should we mention it? How do we deal with that? Then that's, I guess, the next question into what Hiro was mentioning that I would like to send back to him.
Mohammed.
Okay, if I can really, and I agree with you, Isabel, really persuasive. And as I was listening to you, and I thought, well, yes, I mean, maybe we should just let Hiro go on and do the whole sort of hour fast, or as long as we have, because it really sounds persuasive. But I also thought, but maybe sometimes no settlement is better than a fragile settlement. Because you've clarified the issues for the parties. They then from there can plot ahead where they want to. And that perhaps the no settlement can start the transformation for the parties. Maybe separately, maybe they're not meant to be together. And the no settlement clarifies that for them. So they can go separate ways. And that comes up sometimes in the mediation. And I know we're so tied to, as a mediator, we must settle because that's why we are there. The parties want us to settle. But over the years, I started realizing that maybe a no settlement is better for the parties. I know in the minority of cases, perhaps, but sometimes that may just be what it should be.
Yeah, if I could just chime in. So I think Mohammed is making a very important point, and I think it underscores the fact that, you know, it's difficult to say that there is one answer to this question. I think it really depends on the context, right? So I'm primarily in the commercial mediation sphere where people are paying me a lot of money to mediate their cases, and as much as I, subscribe to the ideal that the goal of mediation should not be to settle, because if you're better off going to court, then you should do that. So the reality is that most of the time you're not better off going to court. But my role is not to kind of force you to settle at all costs. My role is to really interrogate the situation with you and do a risk analysis and help you figure out whether settling actually is in your best interest. And, there is this whole line of thought about transformative mediation. And those of us who read the book, The Promise of Mediation by Folger and Bush, know that in transformative mediation, the purpose is really not to problem solve. The purpose is not to try and settle. And that, as Mohammed mentioned, sometimes it's better not to settle because the real goal is transformation. And sometimes transformation only comes because there was no agreement or settlement. And so I think the answer to Isabel's question will probably be very context dependent. I think from my own point of view, so I wear a number of different hats, right? So I'm a commercial mediator. And, I think as a commercial mediator, so as I said before, I think I'm already doing my part with sustainability because I'm helping parties to mediate rather than litigate, right? So let's take the pressure off us a little bit, right? Because just by being associated with the field of mediation, I think we're doing a lot in terms of sustainability, and let's not forget that. But as a commercial mediator, I think, what else can I do to advance, sustainability besides perhaps, recommending that we have a Zoom mediation versus fly in from various destinations or submit everything electronically rather than in paper bundles. I don't know that there's a whole lot more that I can do, and we can talk about some examples of how this plays out in commercial mediation. I do also want to kind of signal that there are whole lots of other ways to be involved in the mediation field. So many of us in the audience, and in fact, many of the most influential people in the mediation field are not necessarily neutrals, right? They're educators, they're reformers, they're policymakers in the mediation space. And I think there's a whole other conversation here about how to promote sustainability in these other contexts where we're not necessarily acting as the neutral, but we may be doing other things that help promote this very sustainable practice of mediation.
Yeah.
I wondered if I could pick up on some of these thoughts from Jimena and Nikki also, because Nikki, you were talking about sort of whether the mediator can play a role in kind of modeling good conflict resolution behaviors and whether that can kind of rub off on the parties for the future and so on. And, Jimena, what you said that spoke to me was, you're pointing to this kind of disconnect on some level between the ideal and the real in mediation. Right. And I think this is something that we as trainers of mediation, and I have some more to say about training, but, we typically train in a very interest-based and idealistic and maybe even transformative kind of way, trying to promote mutual understanding and so on. But the harsh reality in many cases is that that's really not even where the parties want to be at, right? I think many of us as conflict resolvers, we have this inner fantasy, right, of being able to produce some deep healing between the parties, or maybe some kind of emotional catharsis that leads them to evolve somehow into better human beings. And I want to give you an example of mediations kind of similar to, I think, the case that Mohammed was just mentioning. So I mediated once a 20-year-old dispute between 3 generations of family business. And there were multiple, cousins and siblings and step-parents involved. And during one caucus, a very emotional family member explained to me that the root cause of this business dispute among all the family members was a long-standing conflict between her mother and another family member, which she thought that the younger generation, they were just oblivious to, they had no idea. And that this really was the real reason for all the bitterness and the misunderstanding between the parties. So, of course, in pursuit of this ideal of deep healing, I suggested that I facilitate a conversation between this person and her younger relative so she could explain some of this background. And, as emotional as she was also very adamant that she didn't want to do this because she felt that truth would be too painful for her relatives to hear. And she felt that would really just tear the family apart. And so, she was very clear to me that rather than work through that conflict, she preferred for the family business, which had been around for generations, to be divided up for monetary settlements. And of course, as a mediator, that's an unsatisfying, conclusion to the mediation in a way. But I think that we as mediators also have to take the parties as we find them, right? And also have some respect for this value of party self-determination. So if they want to keep it at the more quote unquote superficial level of money, on some level, the question is, who are we to push them in a different direction because of our own conceptions about, what might be good for sustainability or transformation?
I think it's an incredibly important point, not just the question of outcome neutrality, but what people leaving the autonomy and respecting autonomy rather than our own decisions about what should or shouldn't be involved in this in their disputes. And I want to pick up the point in a minute about the issues around things like training and that element of things. But before we move on to that, I'd just like to pick up within the boundaries of outcome neutrality and trust in the parties. I was looking at the Sustainability Development Goals, and it's quite an interesting read. I would recommend it also to our audience, because it might sound like just something over there that isn't really relevant to me, particularly maybe if you're in high income context. But so many of the things that are mentioned in there are fundamentally sort of headlines around the sort of disputes that we deal with. So ensuring sustainable consumption and production patterns, building resilient infrastructure, promoting inclusive and sustainable industrialization, fostering innovation. Those are the sort of things that actually turn up in that. So I suppose one more question to you as mediators in relation to some of those things. If we accept the fact that we don't have the right, or that it's not necessarily appropriate to push people into talking about sustainability if it's not what they're already concerned with, are there situations, are there contexts that you've been in when things relating to that have been intricately part of what you've been dealing with within mediation? And if so, how have you dealt with it? So if any of those development goals, which also include respect for workplace environments, so
I could try to see this, not from the transformational point of view, but from how mediation can help create this groundwork for a sustainable development for the region or for the country, right? It's not a mediator being transformative in itself, but just creating the circumstances that are appropriate for the country, for the parties, for the companies to reach these sustainability goals it's just a broader, as I mentioned at the beginning, a very broad view of the impact that we as mediators can have in the future, and also the responsibility that we as mediators can have in the future. And that's a provocative question that Isabel has and Nikki has put for us in this conversation, and something, to be honest with you, that I haven't thought of. But I was invited to talk about investor state and government cases, and I've been thinking, this, in a way, they are helping sustainability. I've never really thought about it before, but they are. And the work that we are doing case by case is changing the way things are done in a broader sense. And it's helping finding new ways to settle, to save resources, to find ways to deal with things environmentally correct or environmentally right. And this is case by case. So one mediator, you never really think of this case is going to impact this many issues. But once you're done, and when you think back, and when Isabel comes and say, have you thought about sustainability? Then you start thinking, maybe yes, we saved so many jobs. We helped the investment to continue. We allowed for the company to continue existing. I've had cases when you have companies that are about to go bankruptcy because of a controversy with the government. And if it wasn't for mediation, they would be bankrupt now and with a lot of people losing their jobs, but they find settlements. So you are helping and creating a broader impact. But I've never really thought of. So that's, what's so provocative of these questions on how we can actually exponentiate, if that's a word, exponentiate this impact that we have as mediators in each one of our cases.
Thank you, Ilona. I'm looking at you, Mohammed, because on the left-hand side of my screen, it says, promote sustained, inclusive and sustainable economic growth, full and productive employment and decent work for all. That's number 8. And any thoughts?
Yeah, look, we've got what is called the CCMA, which is a Commission for Conciliation, Mediation, and Arbitration. And we've got bargaining council. So if there are labor disputes, and because obviously it involves big business, big unions, they have to come to the CCMA. And the first compulsory process is, as I said earlier, conciliation or mediation. We use the words interchangeably in South Africa. And often we put processes in place for the business and the unions because we often realize there's a fractured working relationship. They're very aggressive towards each other. They're very positional when they bargain annually for collective bargaining. And then through the mediation, we reach agreements on relationship building initiatives. And they put in place teams or task teams or whatever you may call it. And they together work, and they often have built into that training, a negotiation skill training, business skills training, and that assists the parties, and that as a result of mediation. So there is a role for mediation in that to assist the parties in their labor disputes and in their ongoing relationship. They then become partners. We've had a good example of Mercedes-Benz in South Africa, where the unions and management, as a result of mediation, got together, and they're now building one of the cars for export, and it's been rated as one of the best in the world for Mercedes-Benz in South Africa rather than in Germany. And that was as a result of mediation, and it led to transformation because it got them to deal as partners rather than, we negotiating on behalf of employees and you negotiating on behalf of your shareholders. They saw it as a partnership, which came about as a result of the mediation.
That sounds like quite an interesting sort of tiered sort of situation where some of the same skills are being used and taught and replicated at different levels through a system that hopefully it's one small contribution, but it's a contribution nonetheless.
Sorry, if I can just add, we also have another project, which is a school project, because some of these schools the kids were involved in drugs, alcohol abuse, they were in teenage gang fights and things. And we got I wasn't personally involved, but colleagues of mine were involved in this. And they got the community leaders together, they got the parents together, they got the school educators, the teachers together, and they got the students, the pupils or the learners. They call different things in different parts of the world, I suppose, and in different schools. They got them together. And they then started training what they call peer mediation training for the kids. And now the kids that have been trained have these big sort of badges on them, either on the back or in the front, which says, I'm a mediator. So any of the kids who have any problems, school-related, community-related, come to these kids who've been schooled, who've been trained in peer mediation, and tell them what their problems are, and they then, using the mediation skills, conflict negotiation skills, will sort of set up meetings and take it further. And that seems to be working. academic level has increased, the drug abuse and alcohol abuse and gang fights have diminished in those schools where it was, and it's really been a successful project.
It's a really interesting area, and it's interesting how uneven, different across the world it is in terms of which types of mediation are used in different contexts. So I know, for instance, Germany has had a peer mediation program for quite a long time, but there's very little high-level commercial mediation there. So it's quite common that you'll see a lot of mediation in one sphere or in a couple of spheres within a country, and not so much in others. And I think sometimes there's actually a sort of negative association of, well, if kids are doing it, then it can't be something for grown-ups, for instance, or but I think there's all sorts of other things in play. But I want to just pick up, and I promise I won't keep on throwing SDGs at you, but I've got to mention 16. And if you don't know on this call what SDG 16 is, then shame on you. So from now on, you will know. Promote peaceful and inclusive societies for sustainable development. And here the bit for those, particularly in the civil commercial, provide access to justice for all and build effective, accountable and inclusive institutions at all levels. So there's the stuff that we do within mediations, and then there's also what we do as a profession around mediation, access to justice, and dispute and conflict systems within the jurisdictions we're in. And I know this is something that, Hiro, it's very close to your heart. I can see you nodding as well. So I'm going to hand the mic to you on this one, some thoughts on that.
And I just wanted to say, I popped a link to the SDGs in the chat for everybody, so you can brush up, because we don't all know them by heart, as does it.
Got it. And thanks for that question, Isabel. Let me just clarify that I hope I'm not coming across as the person who's poo-pooing sustainability in mediation. As I said before, I think that really mediation is the sustainable option, and we should be using the sustainability angle to promote mediation and convince more skeptics to embrace it. There really isn't a choice anymore. It's either we learn how to do mediation and make it a reality, or we suffer the consequences. And so Isabel was talking about institutions and creating effective and sustainable institutions. And part of the work that I do is in mediation reform. So I've done a number of projects in developing countries around training and setting up, for example, court annex mediation programs. And sometimes mediation programs and centers like these are set up with a lot of fanfare, with consultants usually from the global north being flown in to give speeches or participate in meet and greets and so on. But once the centers have been set up, the donor-funded consultants generally leave, and it's up to the local practitioners really to keep the centers running. And it's no secret that many of these centers quickly stop functioning in these situations. And so I do think there is a need for a more sustainable approach to the establishment of mediation institutions and centers. And this actually takes a lot of thought in planning. Before you even announce the creation of a new mediation center, you have to engage stakeholders, you have to get their buy-in, you have to design thoughtfully processes that are suitable for local contexts and also local constraints. And more importantly, you have to check in with the center on a regular basis after it's been launched. You need to collect data, you need to get feedback from council and parties so that you can identify what is working and what is not working. And you have to be prepared, I think, to troubleshoot with the center 1, 2, 3, 5, 10 years down the line to ensure that initial investment will pay dividends into the future. And so I guess one message that I'd like to convey is that the next time any one of you, whether it's Jimena or Mohammed or anyone in the audience, gets an invitation to participate in setting up a center or maybe speaking at an opening ceremony, please think about whether you are lending your credibility or legitimacy to a project that will ultimately be unsustainable. Because when mediation centers fail, or their work is somehow substandard, it reinforces the idea held by many out there that mediation is just a form of second-class justice. So my message would be, don't just accept that invitation because it would be fun to fly to Turkey or Vietnam and hobnob with Supreme Court justices. Ask the difficult questions of the organizers about how this particular project or institution will be sustainable after all of the fanfare is over. And really just make sure that whatever project you participate in has a sound plan in place for sustainability.
Yeah, Himana.
Oh, I just want to go on to what Ciarb is mentioning, and again, and I love this conversation because I agree with him. We had a project funded by the World Bank to create dozens of mediation centers around the country. They lasted a few months. Money ran out. These centers disappeared, and they were there registered. So there is this concept also of developing mediation sustainably, and that's you're gonna devote your energy and your time to create an institution. You need to think about the market. You need to think about who's going to come to the mediation. You need to think about how to develop a demand of mediation. In Ecuador, we are a voluntary process. It's different from a lot of countries in the region that mediation is mandatory, and it doesn't really work. That's my humble opinion. But in Ecuador, it's voluntary. So if we are going to do a mediation institution, you need to know who your target market is going to be and how you're going to get them to come to the mediation. We had this project with the defense public defenders kind of version from in Ecuador, Defensoría Pública, it's called, and they came to me and said, we want to have a mediation center around the country to attend cases of low profile, small claims of people that cannot afford a lawyer, and we want to do this. Okay, so tell me about the project, and let's work on how you're going to actually make it, how you're going to train your public defenders to come to the mediations representing the clients that are coming and help them be the promoters of your own center. And that was magic. You now have a mediation center all around the country that is dealing with this kind of cases. And because of the public defenders that are already in place, they are the ones to suggest to their people, let's do mediation. And it's helping a lot with the conflictivity of the country. So it's I just wanted to step on what Ciarb was mentioning.
I think it's a point very, very well made. I think there's more experience to draw on from South Africa too, I'm sure, in this regard. Just before I hand over, I want to just throw in the fact that the jurisdiction of England and Wales, as some of our listeners will be aware, is currently grappling with this lovely idea that, and as I moved into the civil commercial context in 2003, I'm often struck by how many of the exact same conversations we are having 20 years on that we were having then about how great mediation is and how everybody is or should do it because it's so great, and yet actually the take-up never follows the level of expectation, and therefore the question of why it doesn't and how you change that, Jimena. And I do sometimes feel like I'm getting I'm a little bit of a broken record, and that if you carry on doing the same thing expecting a different outcome, it's a sign of, well, so I suppose there's an interesting question there in terms of the effective, accountable, inclusive institutions that actually have these processes coming to them. How do you build them? What experience do we have about actually making that work? So over to you, Mohammed.
Yeah, look, South Africa initially, and this was pre-apartheid, obviously, we had voluntary mediation, and we had support from all over the world. We had support from ACAS in the UK, we had support from the United States, we had support from Germany, from Australia, from mediation bodies all over the world, and they came in and assisted. And in fact, we got training from these people in terms of, and it was labor mediation. Mainly, and it was voluntary totally. There was no thing. And as a result of this, as the change came about, and then after sort of post-apartheid, they set up the official body, which is the Commission for Conciliation, Mediation, and Arbitration. And they made absolutely sure that the mediators and the arbitrators at these bodies are highly trained and know exactly what they are for and are guided by the Labor Relations Act. As I said earlier, you know what the Labor Relations Act, in fact, is for. So, and that seems to be working well, and it follows on what you said, Isabel, in terms of restorative justice and the creation of durable peace, because prior to this, employers were exploiting employees. There was nothing they could do. They could obviously withhold labor to put pressure on employers. But as a result of the change in the labor legislation, making mediation compulsory before arbitration or before going to the labor court, it has created transformation. There's been major changes between employees. There's still a lot of adversarial relationships. I'm not saying, you know, it's not all going well, but many of the organizations have bought into it, have realized the advantages of it, have built in training programs for their people, have sort of started relationship building initiatives, buy into workplace mediation. So, and in that sense, there has been a transformation as a result of a legitimate government-funded, although independent of government. In fact, the board of the CCMA is made up of employer representatives, trade union representatives, and it's government, employers, and unions. So it's a tripartite structure and totally independent of government. And that seems to be working really well.
I think that's sorry, Vicky.
No. I just thought that it might be a nice moment to weave in one of the questions from the audience, because I think there's some very provocative and multi-layered aspects to this question that tie in a little bit to some of the issues we've been discussing. The audience member says that, first of all, there are some matters, some cases that need to go to court for a new point of law, for witness cross-examination. For me, that gets at the question of when mediation, right? When in the process is mediation appropriate, if ever? The next thing that the questioner notes is that many cases should be mediated on a compulsory basis. And that, I think, tugs at Jimena's point a little bit. Should it be mandatory? In New York, we've established presumptive dispute resolution, but not quite mandatory. That gets at, I think, a tension between the voluntariness of the process and how the parties are coming to the table if they're mandated to be there. And then the final provocative aspect of this questioner's interrogation or point is that there should be qualified and insured mediators, but not necessarily lawyers. Keep lawyers out of mediation. So I wanted to just lay out those points because I think that they're all quite interesting, and gather your reactions and also kind of tying in what Mohammed had just said. So I know there's a lot out there, but please.
Perhaps I could answer some of that. In South Africa, in fact, the court mediators are not lawyers, and mediators at the labor dispute bodies are not lawyers. Some of them are lawyers, and they've chosen not to litigate rather than to be mediators rather than go the court route. So they've in fact given up their law practice to come into mediation. But the majority of the mediators at the Commission for Conciliation, Mediation, at the bargaining councils, and in fact in private mediation are non-lawyers. So yes, and yes, some cases need to go to court because they're not going to find joy at mediation. And I think that's a point that Hiro made earlier.
If I could just chime in. So I think the questioner was mentioning mandatory mediation, of course, a very controversial topic. We have to be careful about the way that we design mandatory mediation programs, because there have been certain variants of the mandatory model, namely one where it's mandated to go to an information session to learn more about the mediation process and get a sign-off sheet before you can then commence your litigation, which have completely backfired in several jurisdictions and have just really given mediation a bad name. So a lot of the devil is in the details. I think mandatory mediation has certainly been helpful in many jurisdictions and can really kind of encourage lawyers and parties to try something that they otherwise wouldn't opt into from scratch. In other words, if the default is that you have to try this process, and you can always walk away if after a couple of hours you feel that it's not been productive, sometimes that is a really helpful way of changing minds. So it's a live debate still. The other question is lawyers, and whether we should exclude lawyers from the mediation process. Maybe they make mediation more difficult or more fragile than they need to be. Certainly, I've heard stories about how where lawyers are not involved and the parties convene a joint session and have a heart-to-heart. That can be incredibly productive. And I've actually used that technique in several mediations in the past. I don't think that it's helpful, though, to exclude groups like lawyers. And I think fundamentally, without the support and the buy-in of lawyers, it is just in practice very difficult to get mediation off the ground in many jurisdictions. So I think it's important to acknowledge the potential downsides of having certain types of lawyers involved, but I think that with training and awareness over mediation advocacy and so on, I think that lawyers can play a very crucial role in this.
Thank you. I think there's also, bearing in mind the global audience, there's quite a bit of difference in terms of how this plays out and what the role of both judiciary, which the question also mentions, and lawyers plays out, and how that can play out very differently in different types of civil jurisdiction and common law jurisdiction, depending on what the expectations is of what they do or don't do. So there's also the range of examples where compulsory mediation has been introduced that is then done by judges, which is also an interesting variant. Which it goes in the exact sort of diametric opposite and quite extreme opposite of Richard's recommendation of keeping mediation quite close to the legal system.
The questioner also mentioned something about qualified mediators, and I think that's also an important point, right? So there are examples of countries that have implemented mandatory mediation programs. And so consequently now hundreds and thousands of cases are going to mediation, but the problem is that they don't have a robust enough cadre of qualified, experienced mediators to take on those cases. And that's also a danger, because it's one thing to brag about how many cases are going to mediation in your jurisdiction, but if the participants in that mediation are having a terrible experience in that process, it's not a great thing for mediation either.
I think that's absolutely right. I mean, and there's a couple of jurisdictions that have introduced mandatory mediation in pretty much all cases from the beginning of this year. I don't know what the data is like on what's happening there. I have to say, in my experience, in most of the jurisdictions I've ever been to, it's always the reverse problem, though. You've got vast numbers of mediators trained with very few mediations for them to do. So this comes back to this question of what can we do as mediators without doing the same thing of suggesting, well, we've just got to tell people about mediation because we've been doing that. Like, what else can we do differently to actually start breaking that mold? And I'm going to use, I'm afraid I took your name in vain, Primana, and I mentioned something that you said to me in a conversation with government authorities recently about the Ethiopia on the brain, Ecuadorian government's commitment to mediation. and using mediation. And that being a really interesting example here on, and Mohammed, I'm not sure whether you're aware of that, but Jimena is the expert on this, but the impact that government commitment has made.
Thank you so much for the question, Isabel. So just for you to know, I was listening to past series of this webinar, and I heard Laura Abrahamson talk about Occidental case and how they had this controversy with Ecuador. And they wanted to sit down and actually sat down with the government officials, and they said, yes, you're right, and, you know, we need to pay you, but there is no way that we can mediate, so let's go to arbitration. And it was terrible. Oxy, of course, was paid, but it was terrible for the country. So that's true. And it's true, you know, Ecuador as a civil law country wasn't used to mediate cases between the government and the private party. And not even to think about investor state. It was something that was absolutely out of the question. Tax law was considered not subject to mediation as a matter of law. So it was just the frame of mind and the paradigm that we had back then. And even though this happened in 2002, in 1997, we already had a legislation in place that said that public entities were allowed to be part of a mediation, but they had no idea how to do this. So one of the questions that I had when I was part of the Weinstein Fellowship Program at JAMS is, how do we make this happen? You know, this is beautiful in the United States, but in Ecuador, I talk about this and it looks like Narnia. It's like I'm opening the door and, you know, there is the lion and the queen, but it's not real. It's just, you know, my imagination. So it's been, I have to say, it's been a path. It's been a day-to-day work, try to get people to come up to speed into what mediation is. Today, Ecuador has about 130,000 mediation cases in the country, and it's the most normal thing in the world. Every lawyer thinks about going to a mediation before having to go to court. And there's a lot of mediation centers, a lot of mediators that provide services, and it's a profession at this point in Ecuador, which is very amazing compared to a lot of other experiences in civil law countries particularly. So how did we do it for public cases? I think one of the key issues for us was, and I remember this is what I was going with when I asked in JAMS, how do you do this? They said to me, demonstrate. You need to demonstrate that mediation works. So I came back and I had, you know, people saying, what's your mediation style? If there is evaluative or facilitative. Mine is the Nike approach. It's really just do it. Get it done, you know, have the parties and talk to them. And I, you know, I say I'm a professional meddler, but I talk to them and try to get them to trust into trying a mediation. And once you have one or two cases that are complex enough for the lawyers, then it starts to happen. How we did it with the state, specifically with the states, is we developed a process that worked. And we created a process that made a lot of emphasis on confidentiality of the mediation process, which basically means that the public functionaries that come to the mediation, they are not responsible for whatever it is that they say in that session, and that everything they talk, it's going to be confidential and it's not legally, it doesn't exist legally. So if we don't reach a settlement, nothing happened. And that's okay, we didn't even have a mediation, right? But if we reach a settlement, then we have this other phase of the mediation process, which is we as a mediator, or I as a mediator, I'm helping the public administration to create its will. You know, you have to ensure that the will of the public administration is made formally. So you have to go through a technical report with the technical person of the institution, a legal report from the legal person of the institution, have a fund certification from the economic person of the institution, and then get the authorization of the Attorney General according to our law. So if you go through all this and you have all this paperwork there to be part of the settlement agreement, only then you can sign a settlement agreement. So the settlement agreement is born to life with every complying with the rule of law and complying with every control that there could be. And then you have this third part of it is that this agreement should be transparent because you're talking about public interests. You cannot do things behind closed doors. So mediation has gained this incredible reputation of being trustworthy, of being ethical, of being transparent, and of being efficient. If you can mediate cases with the government that are the most complex from the legal point of view and the most complex from technical and political point of view, and you can get them settled with benefits that can be promoted around the country, then everybody else thinks that this is something worth it. You know, you were mentioning peer mediation doesn't seem, it's just something kids do, then grown-ups don't do it. It's the opposite, right? If government can settle, then any other case can be settled. And lawyers started to trust the process and come to mediation. I think part of this is because we demonstrated with the most complex cases there are. And that's how Ecuador started booming. Mediation has started booming here. And it's, you know, I think it's done. Done it.
Thank you, Jimena. I think we've got a maximum of 10 minutes left. We should probably stick with 9 if possible. So for me, that probably means we hand over the mic for a once around the table. What do you take away from this discussion of fragile settlement or transformational development and sustainability and the many thoughts and the complexity? If you have one thought of your takeaway, what would it be? So I'm going to, I think Mohammed was the last person to not speak, so to speak. I'm confusing myself. It is nearly 11 o'clock at night. I'll just point that out. Mohammed, one thought to close with.
Well, I think, yeah, the important thing, and in South Africa we have DISEC, which is the Dispute Settlement Accreditation Authority. And I like the idea of mediators being accredited, being highly qualified, not necessarily being lawyers. And I'm not excluding lawyers. Lawyers could be mediators. And I think if we have that and we can build on that, and then, and of course, as was said earlier, sort of because DISEC will ensure ethical behavior by mediation, by mediators will ensure that it is professionally run. And as Hiro said earlier, also, if you involve in a body, ensure that it's a credible body. And DISEC will do that for us in South Africa. And I think that's important. And I think that came up today as well, that it's important that you have credible mediators mediating.
Thank you. I think it's a really important point. Hiro.
So, one takeaway for me is that it really does depend on the context when we're talking about the relationship between sustainability and mediation. Obviously, everything is affected by sustainability, from the foods that we eat to the way that we, work and the way that we spend our free time. So obviously there is a clear import for sustainability for mediation. But I think a lot of it is in the particular context. I think we heard from Jimena largely about kind of public international law disputes that involve states. And really, I think the import for sustainability is very different in that context from the kinds of disputes that I often handle, which are between private parties. We heard from Mohammed about the South African Commission. And to me, the reason why that's a successful, sustainable model is that it's really about designing a system going forward to effectuate some of these sustainability ideals. I think it may be harder to do some of that in the context of a private mediation between commercial parties. So the context really matters. And I think we're already doing a whole lot just by being involved in the mediation endeavor.
Thank you, Hiro. Jimena.
Well, I always thought that I was on a mission to promote peace and create mediation. I know it sounds very naive, but people that know me know that I'm a little bit crazy. I think that this panel and this conversation has made it more relevant. So this mission is not only promote peace and promote mediation, but it's actually promote development and sustainability. That's what mediation is actually helping reach, and that's bigger, even bigger than we thought before. And even if we don't realize in one case by case, I think that's the thing that that has stayed in my head after today.
Thank you. That's wonderful. Nikki.
Well, I want to say thank you to everybody for participating, and for everybody who has participated both as an audience member and as a panelist throughout this 6-part series. I think that ending on sustainability is a really important note. One of the papers that underlies this session defines sustainability as a common concern of humankind. And I don't want to get too, get out our violins and get too kind of orchestral, but I do think that the fact that so many people see possibility and potential for mediation to be a really useful tool in helping to address sustainability concerns speaks really highly of the future that we all have as a community of dispute resolution professionals and students and theorists around the world. I think that there's a lot of work to be done. As many of you and the panelists said, it's really important that first experience with mediation be a good one. And I think that that's something that we battle continuously. So we have to make sure that we are attending these kinds of discussions, asking difficult questions, ensuring that the process and the people who are responsible for leading and guiding the process are qualified and ethical and informed and culturally appropriate. And really, there is no one big answer, but I think that one of the things that we should continue is this robust discussion all the way through. So I want to just thank you, and especially the Chartered Institute and Isabel for masterfully leading this discussion. JAMS bringing the commercial kind of context into focus and into position in this broader world of conflict resolution has been just a wonderful opportunity that we hope to continue.
Thank you, Nikki. Well said, and well said to all of you. I think my final word on this would be just how multifaceted the contribution seems to be that mediation can make actually to sustainability. Just looking across those different goals, and just one thing which I always come back to again and again is, as mediator, is that the fact that I'm dealing with the personal, the legal, and the commercial. And if I use that same structure to just think about what am I doing personally in relation to in my mediation practice, and how sustainable is what am I doing personally? What am I doing commercially? And what are my parties doing commercially? And where are they asking me to facilitate something? Am I just to make sure I'm not being tone deaf because I'm making assumptions about what they might not or might not want because they're commercial and they clearly don't care about this stuff. But actually, if we think about some of the things that actually even multinationals are very concerned about in terms of image and so on, it's worth thinking about. And of course, the legal is an integral aspect of something, but it's not the only aspect of the peaceful, inclusive society for sustainable development, access to justice, and building effective and accountable institutions. And that, again, I think this question of how sustainable our systems are, what else do we need to do, and how do we need to carry on adapting into the future as the world changes at such high speed, and with some of the enormous challenges that we're facing. And that's why we started this series, with the huge challenge of the war in Ukraine and the waking up, if you like, to something that much the rest of the world has lived with or lives with on a constant basis, which is armed conflict and war, and that being a bit of a wake-up call to maybe some of the states who've been lucky enough to not be in that situation for many, many years. But I think going forward, this is something which is really a challenge to all of us, and that some of, hopefully, our training, if we put it to good use, could be helpful in making a contribution, however small, to how do we deal with this on the tiny, the medi, and the macro levels. So thank you for joining us. I hope somebody will just pop an answer to Gert Nielsen about MIAMs that backfired into the chat. That would be great. And I look forward to hopefully meeting you, seeing you in other contexts. And a particularly big thank you from me personally to everybody who's participated in the Ciarb Mediation Symposium 2022, and to all of you who've watched or participated in the Acute Dispute series. Thank you, and good morning, good evening, and for me, good night.
Good night, and it's midnight.